get started. Welcome everyone to the Humanitarian Academy at Harvard Lecture Series. Today's talk is being co-hosted by the Humanitarian Academy and the Human Rights Program here at the Harvard Law School. But before we get started, I just want to take a quick moment to tell you a little bit about the Academy. This is a relatively new initiative that was launched in May of last year thanks to the generous support of two Harvard alumni, Jonathan and Jean Levine, who are extremely committed to public service and furthering the field of humanitarian action. The effort is really a cross-university resource and platform for curriculum development, education and training in humanitarian studies for students and for humanitarian professionals in the field. And we'll have a series of events coming up, and our next lecture actually in the series is co-hosted with the Department of Global Health and Population at the Harvard School of Public Health in Longwood, entitled Proactive Response of Public Health to Disaster Risk Reduction, the Case in Iran. That's going to be a discussion panel. I think it's going to be a very interesting talk, so I encourage you to check back on the website as we get closer to that event on April 1st. And with that, I just wanted to say that we're extremely honored to be joined today by Andrew Cayley, Queen's Counsel and the United Nations Chief International Co-Prosecutor of the Extraordinary Chambers in the Courts of Cambodia. Andrew's had an impressive career in international criminal law, serving at the International Criminal Tribunal of the former Yugoslavia, International Criminal Court, Special Court for Sierra Leone, and the ECCC. And usually, Cayley has defended and prosecuted before the international courts. Cayley was responsible for the Security Council referred investigation into serious human rights violations in the Darfur region, Sudan. He applied for the first criminal charges in the Darfur situation. From 2001 to 2005, he was a senior prosecuting counsel at the ICTY. He laid the current charges against Ratko Mladic and led the first prosecution of the members of the Kosovo Liberation Army for crimes against humanity and war crimes. From 1994 to 2001, Cayley was prosecuting counsel at ICTY, where he worked on many cases, including the Kostic case, where the prosecution team secured the first conviction for genocide in Europe since the Second World War. In November 2011, Cayley was presented to the Assembly of States Parties of the Rome Statute as one of 4 candidates to be the next prosecutor of the International Criminal Court. And in March 2012, on the advice of Lord Chancellor and Minister of Health, he was appointed King's Counsel by Her Majesty Queen Elizabeth II. He was appointed International Co-Prosecutor of the ECCC in November 2009. And without further delay, please join me in welcoming Andrew Cayley.
Thank you very much for that generous introduction. You can see I was simply in the right place at the right time, which is why I had the opportunity to be involved in many of these cases. Anyway, thank you very much indeed for this kind invitation to speak today from the Humanitarian Academy and the Human Rights Program at Harvard. I do love coming back to this place. It gives me some space to reflect in the calm. The youngest member of the audience is upset already, but it's always nice to get away from the heat and the hurly-burly of Phnom Penh. This university has always shown a very great interest in the work of the court, the ECCC, and this, of course, reflects the deep roots of human rights and international humanitarian law, found not just in the Faculty of Law, but in this academy and institutes and centres spread across the campus. I'd like to particularly thank Dr. Phong Pham and Dr. Eliza Hoven, who made this trip here to the United States and Harvard possible. Probably most of you know in the room that I work for a court that's completely bankrupt, so without their help I would have had to have come from Cambodia by bicycle, so I'd still be on my way. My remarks today will be structured as follows. I'm going to first comment on the role played by capacity development, at least from my viewpoint. So general comments about capacity building in a transitional justice context. Next, I'll briefly talk about the court, the ECCC. That I'll highlight what I believe our contribution has been to capacity building through transitional justice. And then lastly, I'll make some closing remarks. I think we're running a bit short of time, so I may have to abbreviate matters. Before going into the substance of my talk, I would just like to publicly acknowledge 2 people that assisted me with this talk, because I've been rather busy in the courtroom of late. Ran Xiaozhu, an intern from Singapore in my office who did a lot of the work on what you're about to hear. And secondly, Vanore Sok on my staff at the OCP, who, armed with local knowledge, provided input on the draft of the text of what I'm going to speak to you about today. Achieving justice in peacetime is a challenging enough process, but achieving justice in times of transition from state repression or conflict is an endeavour which brings with it a whole host of challenges and aspirations. Obviously, the process that we're going through at the ECC, we're trying to find redress for victims. We want to recognise their suffering and their rights. But we're also trying to promote civic trust and strengthen the rule of law in Cambodia. I wouldn't call it democratic rule of law, but we're certainly trying to strengthen it. The provision also of an opportunity to a transitional society like Cambodia to essentially reinvent itself, even as it's actually rebuilding itself. As a society, it's looking to restore order, stability, and actually find faith in itself again, with a view to preventing the recurrence of past transgressions. And in fact, in Cambodia, they're obsessed with that, the fact that there may be another war at some time. The key that I believe, the key to all of this is to generate a thirst for change from within the system. You can spend millions of dollars, but if you don't actually inspire and embolden individuals working within the system, you go absolutely nowhere with transitional justice. If you just try and work on actually reforming institutions, and I mean, I know it's stating the obvious, but I've seen so many failed projects, millions of dollars spent on trying to change institutions without actually addressing the very people that work within them. It really goes absolutely nowhere. Thus, domestic participation at a personal level is fundamental to get any value in making these changes. You have to recall that you're dealing with societies that are nursing damage inflicted upon their intellectual, institutional and social infrastructure. Capacity development is thus an integral part of any form of national recovery. Just some preliminary thoughts on capacity building. And again, I know I'm probably stating the obvious for many of you in this room, but it's worth actually talking about it generally before talking about Cambodia specifically, because then you'll see the immense challenges we have in Cambodia. Capacity development can be thought of as the process through which individuals, organisations and societies obtain, strengthen and maintain the capabilities to set and achieve their own development objectives over time. According to this view, capacity development can occur at three levels in interrelated ways: at the individual level, at an organisational level, and then at a societal level, you know, the organisations, the society being comprised of those organisations. Capacity development on an individual level entails the development of skills, experience and knowledge, and equipping individuals within these broken societies with faculties which will allow them to adapt to change and apply themselves in new ways. At an institutional level, here we're involved in focusing on modernising the machinery of whatever institutions are actually left in the country, particularly in regard to internal systems and processes that determine an organisation's effectiveness. And I'll deal specifically with the legal system so that we're not talking in theoretical terms. Capacity development at a societal level aims to create a more interactive public administration that learns equally from its actions and from the feedback it receives from the population at large. Such development touches upon all the rules, laws, policies, power relations and social norms that govern civic engagement. Now, within this framework, judicial capacity development involves improving access to justice, promoting legal literacy and public awareness, raising the level of gender sensitivity, improving access to legal aid, strengthening court administration, improving case management, and providing training. Judicial reform is a necessary precondition for development in society because stable and just legal systems support the promotion of security, equity, and prosperity. A strong judiciary is an essential contribution to fostering economic stability and growth and to enable all manner of disputes to be resolved within a structured and orderly framework. As noted by the UN Secretary General, These are interesting comments he made. Our experience in the past decade has demonstrated clearly that the consolidation of peace in the immediate post-conflict period, as well as the maintenance of peace in the long term, cannot be achieved unless the population is confident that redress for grievances can be obtained through legitimate structures for the peaceful settlement of disputes and the fair administration of justice. It's interesting to note, actually, in Cambodia, I'll come on to this in more detail in a moment, but not only do they have terrible problems with their criminal justice system, they also have absolutely appalling problems with their civil and commercial courts. And we found that even the work that we're doing in a court that's primarily concerned with criminal justice has actually fed into the civil courts and commercial courts. And as the Secretary General says, it is a very real issue. Investors do not come into developing states if they think they're not ever going to get their money back, if they can't actually recover funds through the commercial courts. And I mean, as you well know, these research agencies that paid vast sums of money to do research on these countries and tell multinational companies what prospects they have of going and working through the local courts. And in Cambodia, this is a very, very large problem, one which has been reduced to some degree by our work, but there's certainly still decades of work that needs to be done. So I've talked in theory, but these issues are very real. I'll try and develop that. Let's talk a little bit about the ECCC, about the Extraordinary Chambers in the Courts of Cambodia. In mid-1997, the government of Cambodia requested assistance from the international community to prosecute individuals for international crimes, genocide, crimes against humanity, grave breaches of the Geneva Conventions committed during the Khmer Rouge era. The leaders of the country asked for the assistance of the United Nations in bringing those most responsible for these crimes to justice. Specifically, the leaders of the country at the time noted that Cambodia did not have the resources or expertise to conduct this very important process. This was later confirmed by a group of experts appointed by the Secretary General and sent to do a review of the country's legal system. Cambodia's request for international assistance reflected the reality that after years of domestic and international conflict in Cambodia, the Cambodian judiciary were really struggling against the odds. 80% of the 400 to 500 lawyers and legal experts who lived in Cambodia before the Khmer Rouge era were murdered by the Pol Pot regime. Legal texts were burnt, courthouses were used as places of torture. The vast majority of legal professionals that survived fled to Vietnam. Interesting statistic, by the end of the Khmer Rouge era, it was estimated that only 10 law graduates remained in the country. So the present day judiciary reflects this very turbulent past. Basic legal principles which are entrenched within the constitution of the country and the Code of Criminal Procedure incorporate many of the fundamental rights that are contained in major treaties and conventions on human rights. However, substantive adherence to the rule of law and enforcement of human rights in the country is very limited and still a great challenge. As I've stated, Cambodia is a country that is recovering from the ravages of warfare. Resources are in very short supply. While legal aid is nominally available in Cambodia for criminal defense, so for individuals accused of criminal offences, legal aid is nominally available. In practice, it's largely unavailable because there are no funds. Because of the volume of work and the lack of capacity in the courts, criminal cases often come to trial at extremely short notice. Sometimes people get 2 hours notice before their trial actually comes to court. So lawyers have little time to actually prepare for the trial. Putting matters in perspective, in 2007, Cambodia only had 142 judges, 72 prosecutors, and 601 court clerks for 23 courts, including the appeals and Supreme Courts. Let me talk very briefly about corruption in the Cambodian legal system. Corruption is a very tricky area. It's often a question that I'm asked when I speak about the court. It undoubtedly still dogs the domestic legal system. But I think, having now lived there for nearly 4 years, you've got to be very careful how you address it. In particular, you've got to remember that legal professionals, judges, earn very, very low salaries. And often corruption is the only way that they or their families can survive. I'm not justifying it, but there are reasons for it. It's not just about greed. If you look at another country in the region, Singapore, they have actually less corruption than the US or the UK. And one of the reasons for that is not because the people are any better than anywhere else. It's simply because they pay their judiciary salaries that make it, absolutely completely unattractive for that individual to be involved in any form of corruption. That's how they solve the corruption issue. And the fact is, when NGOs criticize the Cambodian judiciary or legal professionals for corruption, they don't actually offer any realistic solutions as to how Cambodia is going to address this, because Cambodia cannot afford to pay the kinds of salaries that are paid in Singapore to root out corruption. Again, I don't justify it, and there's more that needs to be done, but it needs to be understood, and most of those who criticize actually never really have any solution to offer. Let's talk about public perception. A recent public poll indicate that most Cambodians have little trust in the national criminal justice system. I think the work of the court has done something to improve the perception of the justice system in Cambodia. We'll talk about that in a moment. The ECCC's hybrid model, and by hybrid, it is a partnership between domestic legal judges and staff and internationals. So, without going into too much of the legal framework of the court, it is a domestic court. It is the product of an agreement between the UN and the Cambodian government and domestic legislation. Unusually, the ICTY, the Yugoslav Tribunal, and the Rwanda tribunals are purely fruits of the United Nations, whereas the ECCC is in fact a domestic court with international and national staff working together. So that's why it's a hybrid court. I think that's a unique aspect of the court, this heightened degree of synergy between the international and national components. That the court is the first hybrid criminal tribunal where national judges form the majority is but one feature of the court's commitment to fostering active domestic participation with a broader objective of capacity development in mind. Let's now talk about our contribution to transitional justice. These are my personal views, what I've seen, but hopefully reflecting some of the framework that I've just given you. Even with the very challenging conditions that we have, I believe, played a part in developing the judicial and legal capacity within Cambodia. As a preliminary point, it cannot be overstated that the in situ location of the court greatly enhances the capacity development function of the ECCC. As the Secretary General has noted, there are, I quote, a number of important benefits to locating tribunals inside the countries concerned, including easier interaction with the local population, closer proximity to the evidence and witnesses, and being more accessible to victims. Such accessibility allows victims and their families to witness the processes in which their former tormentors are brought to account. National location also enhances the national capacity building contribution of the ad hoc tribunals, allowing them to build the skills of national justice personnel. In the nationally located tribunals, international personnel work side by side with their national counterparts, and on-the-job training can be provided to national lawyers, officials and staff. Such benefits, where combined with specially tailored measures for keeping the public informed and effective techniques for capacity building, can help ensure a lasting legacy in the countries concerned. Let me talk first about capacity building at an individual level. Staff members, and here I'm talking about Cambodian staff members, across all the organs of the court have been beneficiaries of capacity development. Staff members employed as lawyers and judges benefit from capacity development, as do staff members involved in court management, including translators, information technology specialists, security teams and medical staff. I believe we provide a fertile ground for the acquisition, honing and practice of the gamut of legal and extra-legal skills and aptitudes. Specifically, what have we done? How have we trained individuals? We have trained them in legal research and writing skills. We've given them, I believe, enhanced understanding of substantive legal issues, specifically in relation to international criminal law. We've enhanced the understanding of core legal principles, such as those particularly pertaining to fair trial rights. We've enhanced the understanding of procedural and evidential rules. We've enhanced the understanding and practice of court management skills, such as how to manage a large multi-party trial with accused in multiple locations, in 3 languages, with document management on a huge scale. And I also believe, very importantly, we've given them very efficient work practices utilizing technology and cross-cultural dialogue. The acquisition, honing and practice of legal and extra-legal skills and aptitudes occurs through formal and informal means in 3 ways. Firstly, the court, the ECCC, provides a practical learning environment away from the daily challenges faced in the domestic legal system, which are mitigated by the international resources and the presence of international personnel. Secondly, this day-to-day practical experience is complemented by a range of in-house training programs. For best effect, capacity building in the form of training must be based on a mutual exchange of ideas. To cite an example, within my office very recently, we organised a mock trial, which we did together with the nationals, senior members of staff like me playing the part of witnesses, and then my staff lawyers actually working together with a Cambodian in examining a witness in the easier circumstances of a mock trial as opposed to a real trial. Thirdly, the volume of evidence in cases before the ECC is on a scale unseen in the domestic legal system. Lawyers, judges and court management staff are challenged to manage copious amounts of evidence in 3 languages spanning decades of events. The ability to investigate and prosecute complex crime is an asset in Cambodia, where there are a number of instances of very large complex trials emerging in areas such as human trafficking and drug trafficking. The scale and complexity of cases at the ECCC provides an unprecedented opportunity for capacity development within the domestic legal system. On a more personal level, the opportunity for experienced international staff to engage with the work of Cambodian staff makes for a unique capacity development experience. We have a mixed office approach in my office. Other offices do it slightly differently, but we pair up an international lawyer with a national lawyer. So if you go to an office, you will find that we basically all sit together. It's not that there's, in some parts of the court, you'll find there's a Cambodian side and an international side, and this has led to immense problems, particularly where there's been some political interference at work in the court. When you're together, at least even if your national counterpart can't work with you on a particular issue because of political sensitivity, at least you are talking about these issues with them, and at least that tension is reduced out of the system. So that's something that I developed when I arrived in the office. International staff's engagement with the work of the Cambodian staff allow for the providing of feedback and scrutiny of work which would otherwise not be available in Cambodia. International staff come from both the common law and the civil law traditions, adding a degree of diversity to the debate which enriches individual knowledge. Perhaps most importantly, international staff are free from the local ties that the domestic, the Cambodian staff have. In order to get a job within the Cambodian prosecution service or be a judge, you have to be a member of the Cambodian People's Party, the ruling party. So for them, as much as NGOs criticise the level of political interference, for them this is an issue of life or death for them and their families. It's survival. These are the kinds of hidden pressures that you have to understand when you're working in this kind of environment. Although the effects of the ECCC are likely to take many years to be fully realised, there is evidence that Cambodian staff members are developing their capacity from their experiences. One court monitor has noted recently that as the trial progressed, there was a visible improvement in the skills demonstrated by the Cambodian trial judges and counsel for the parties. This led the monitor to conclude that the individuals clearly learned from the examples of their international colleagues and their experience within the court. And I do believe that that's a fact. I think I've noticed certainly with national staff members there has been an enormous improvement in the quality of their advocacy in the courtroom, in their written work. And let me add, honestly, the knowledge transfer doesn't just work one way. I need the Cambodian staff members to advise me on the local context. They understand the contours of the government's domestic concerns. They know their own people. They've lived in Cambodia all of their lives. And genuinely, I rely very, very heavily on Cayley, the National Co-Prosecutor, and her deputy, Shakriya Yet. And what they advise me really shapes what I do. It is an extraordinary experiment in international justice. It has many flaws. I think many of the problems that we've had need to be looked at very carefully before this is done again. But I think at a personal level, for me, it's been something that I'm proud of. I'm certainly proud of the development that they've made. Let's talk about at an institutional level. I can't claim that institutions have improved at the same level as individuals, but let's be frank about it. Institutions are comprised of individuals, so it will take more time. Before further comment, a snapshot of the domestic court system is in order. Domestic courts are located in 22 of the 24 provinces across the country. An appellate and supreme court are located in the capital, Phnom Penh. There's a military court in Phnom Penh with jurisdiction over the armed forces. There's also a constitutional council which protects respect for the Constitution, interprets the Constitution and decides on some electoral matters. Then there's the Supreme Council of the Magistracy, which is tasked with ensuring the independence of the judiciary. Two types of capacities that are being developed in the domestic courts as a result of the ECC. First, we're developing capacity in terms of the personnel employed by the domestic courts who are currently working at the ECCC. So what I mean by this is that 10% of the national staff within the ECCC also work in the domestic Cambodian legal system. So they will go back. Indeed, many of them are still working in the domestic Cambodian legal system. To give you an example, my counterpart, the National Co-Prosecutor, is also the Chief Prosecutor before the Supreme Court of Cambodia. So she is working 2 days a week in the Supreme Court, 3 days with me at the ECCC. And you find this reflected throughout the ECCC. Secondly, I believe we're changing the way that law is applied in the domestic legal system. So we're affecting personnel, and secondly, we're affecting the way law is actually applied. Now, not only are we, I think, changing the court through individuals who already work in the system, but we also anticipate that many of the people who work in the ECC now, Cambodians who are not employed in the domestic system, will go to it when the court finishes its work. So there will be a massive transference of skills and insight into the domestic legal system. Also, we are convinced that many of these people, and there are 250 odd Cambodians working in the court, will actually pass on the skills that they've learned to national staff members within the Cambodian courts who've not had the benefit of the ECCC. So it's a sort of trickle-down effect of capacity building. Training sessions, we hope training sessions will be organised as another form of outreach of the court. So in essence, training sessions organised by Cambodians who work in the ECCC now will organise those sessions within the domestic court system, and that's going to be supported by a number of NGOs. Now, this transference of skills is going to take many years, but we see it going on now, and I'm optimistic about that aspect of the court. I think it's important to remember that the skills learned at the ECC can not only just be transferred to individuals, but can be transferred at all levels of the domestic court system. Given the various levels of seniority of the Cambodian staff, and we've got people who are Supreme Court judges right down to junior court clerks, the benefit of capacity development that I've just described can be spread right across all levels of the Cambodian legal system, not to mention all geographic areas of the country. I cannot emphasize to you too much how under-resourced and primitive this system of justice is in Cambodia. I mean, they built it from scratch since '93. They have no resources. Oftentimes there's no electricity in the courtroom. They've got no technology. It's working at a very, very basic level. So even if these individuals that we're talking about are not bringing too much across, they're bringing a hell of a lot, actually, within a system that is completely and utterly dysfunctional. I think this ongoing connection with the domestic court system is very important to act against what Nave Pillay called the reverse legacy phenomenon. The United Nations High Commissioner for Human Rights describes reverse legacy as the process by which a hybrid court drains domestic capacity. So as people want to move from the domestic court system to the international court system because it's better paid, it has more facilities, you end up with all the best legal professionals from the domestic system moving into the international system. And I actually think the ECCC, we've really successfully worked against that, because although, yes, of course, people do want to work in the court, all of these people, and there are hundreds of them, will go back into the domestic system. It's not that they're going to stay for the next 15 years at the Yugoslav Tribunal and never go back to the domestic system. You know, many of these people are working on a daily basis within the domestic system, and within the course of the next 3 years, they'll all go back. The third way in which capacities are being developed in the Cambodian domestic court system pertains to us providing a body of substantive law that can be applied in Cambodian domestic courts. We produce hundreds of decisions, memos and judgments across all three chambers on a very wide variety of topics related to criminal procedure and international criminal law. These decisions are either directly applicable to the Cambodian criminal justice system or should be considered highly persuasive authority. Remember that we are a domestic court within the Cambodian court structure. Our rules of procedure are based on the current Cambodia Criminal Procedure Code. So our court is constantly making decisions on domestic law. It's not sort of pie in the sky, pure international criminal law that's got no application in the domestic system. A lot of what we're deciding will affect how trials proceeding in Cambodia in future years. Just to cite an example, a concrete example of what I'm talking about, the rights of incapacitated defendants. This is an area of law that you can imagine in a country like Cambodia has received scant attention. Even though there is a diminished responsibility defence in Cambodian law, this provision rarely affects the outcome of criminal proceedings. And I recall one case when I first arrived, a terrible case, of a mentally ill woman who was accused of stealing money from a market trader in the central market in Phnom Penh. She was diagnosed as being schizophrenic, not by the Cambodian medical system, but by an NGO psychiatrist. The psychiatrist did not testify, but the defence lawyer, a Cambodian, raised the issue of her schizophrenia as a mental issue defence at trial. The defendant's mental illness was absolutely apparent during the trial, with her testimony becoming erratic and nonsensical, and actually, terrible to say, judges and lawyers in the courtroom were laughing when she was trying to explain what happened to her. It was absolutely one of the most appalling things I've ever seen. Despite this, she was actually convicted of theft and sentenced to 6 years imprisonment. So you can imagine we're dealing with a legal system that's working at a very, very low level, where even legal staff, judges and lawyers are actually laughing at a woman with a very serious mental illness. During the course of the second trial at the ECCC, several of the accused have been examined at various times for mental and physical health concerns. Now, Ying Tirit, who was the female accused, was severed from the trial and conditionally released from detention following an assessment of her unfitness to stand trial as a result of her lack of mental capacity. She was actually suffering from senile dementia. And it's interesting because there was a lot of resistance amongst the national Cambodian staff to make this assessment and to essentially allow her to be severed, to be taken out of the trial and conditionally released back to her home in Phnom Penh, because people simply didn't understand, based on what they saw going on in the domestic legal system and their very primitive understanding of mental illness, as to why this woman should have this medical assessment and then be permitted not to stand trial. But it actually has left, I believe, that particular decision of the judges. We brought in international psychiatrists to do the assessment, who did it alongside national psychiatrists. There's one clinical psychiatrist in Cambodia, one. I mean, I know this is a country that's probably got more psychiatrists than the entire population of the US now, but I joke, but there is one trained clinical psychiatrist in the whole of Cambodia, in a country with enormous mental health issues. So you can see the problems confronting the system. So the nationals worked alongside the internationals. They did an assessment. She was found unfit to stand trial. The judges then made a decision severing her out of the case. So I believe we've made a lasting contribution to developing capacity in the area of law pertaining to the rights of incapacitated defendants in the country, of which there are many. We leave behind a wealth of written transcripts, memos and decisions outlining an internationally sanctioned process and standard to try and replicate in the future when questions of incapacitation arise in domestic courts, which they surely will. As to capacity building in the basic principles underlying the judicial system, we're bolstering respect for the rule of law. While beforehand criminals often remain beyond the law's reach, with the CCC's inception and presence, we've signalled the beginning of an end to the age of impunity. At its heart, we are trying individuals who were previously seen to be above the law, above all criticism and above all sanction. I believe we've made a lasting contribution that essentially previously untouchable people can be prosecuted, and I believe within the course of the next generations that will feed into the domestic legal system. At the moment, it is impossible to be tried of any kind of criminal offence if you are part of the elite in that society. I think we have encroached into that area of society where previously people wouldn't have dreamt of talking of very powerful people being accused and tried for crimes. I think we've sort of nibbled at the edge of that. A long way to go to completely change, but certainly we've begun the process. Specifically, ordinary Cambodians are the ones who are making the prosecution possible. They come to court to face the accused, they give evidence against them. Again, let me emphasize, this is a very, very underdeveloped society. Most of the people who come to court, they don't even know what a court is. They actually have to have the process explained to them. So it's very, very challenging for an individual. It's challenging for any of us to be a witness in criminal proceedings. But for these people, it's like a trek to the planet Mars and back, coming from their village and coming to the court. They're informed on a regular basis all across the country about the trial process. And I think certainly the involvement of Cambodians in the process, they giving evidence, they having access to all of the documents that the court will bequeath when it closes down. This is something very important, and it's often lost, this participation of the population in the process, in the daily flow and to of the court, and of course all of its critics. But it is one of the core functions of the court, and it has significant ramifications and consequences for the country. As well as providing a contribution to substantive law, we're also providing templates to improve Cambodian law. The way the law is presented and assessed is often an overlooked topic, but a definitely important subject when you look to the future of Cambodia. Currently, Cambodian legal decisions are not easily accessible. They're not public. They're often not recorded. There are no online databases of Cambodian case law. We provide a template to help gradually change that. The hundreds of decisions generated by the court, by all of the chambers in the CCC, are being recorded. They are available in Khmer. Khmer judges participated in the drafting of those judgments. All of the legal production in my office is in Khmer and English. This is a huge repository of information which can assist the domestic legal system in the future. These features mean there are few barriers to Cambodian lawyers accessing and using hard law. This is the beginning, I believe, of a uniform law reporting system in Cambodia. It's a long way to go, but many commentators have noted this, and if you go to our website, you will see the library of decisions. And as I say, all of the substantive legal work done in my office will all be passed on to the domestic legal system when we leave. They will get all of this information. Let me look next at the societal level, how it's changed things in society. I think I still have another 15 minutes. On a macro level, capacity is being developed in Cambodian society through the work of the CCC. In addition to developing capacity in the general public, there are two groups whose capacity is particularly developing. First, victims of the Khmer Rouge regime and their families, and secondly, academic institutions, in particular secondary and tertiary groups. Vehicles through which capacity is being developed include public discussion, victim participation, and educational material. Let me look first at public discussion. For the public as a whole, the ECCC provokes discussions on issues such as ending impunity, public access to judicial institutions, the rights of an accused, and the role of the court system in dispute resolution. Knowledge of the trial process and legal rights are enhanced. The ECCC generates discussion among the general public through extensive outreach programs, the opportunity to visit the court, and very wide publicity. We have an extensive outreach program assisted by NGOs and interest groups. We've actually been praised. It's one of the few areas where we've been described as an excellent example for providing and disseminating preliminary basic information as early as possible in the trial period. We convene workshops, often in the provinces, so in remote areas of the country, which have been deeply affected by the Khmer Rouge regime. We promote mutual dialogue between the court and communities. Just to give you some figures, and this is one particular example, the Public Affairs section of the ECCC on the 27th of September 2012 gave a presentation to 1,800 garment factory employees in Praia Sihanouk on the history of the Khmer Rouge and the ongoing trials. Now, they're generally young women. It's a garment factory, very young audience of transplanted workers from all over the country. They were incredibly eager. They're not very well educated people, but they were very eager to hear about the work of the court. It was actually one of the largest outreach activities we've ever sponsored. And it was particularly important because it spoke to a young audience, a demographic that didn't experience the Khmer Rouge and don't really understand it, and oftentimes their parents or grandparents, if they're still alive, don't speak about it. So we've enhanced the younger generation's capacity to actually understand what happened during this period, which is incredibly important as the country moves forward. Now, our efforts are in conjunction with those of human rights groups and other NGOs working to ensure that ordinary Cambodians are able to learn about the ECCC and to raise issues of concern. We also encourage public participation by having people visit the court itself. The trial hearings are mostly open to the public. There's no admission fee, and the court provides free transportation for groups of Cambodians who want to visit. Our public gallery, I think, has a capacity for 350 people attending the hearings, and the vast majority of those actually watching the proceedings are Cambodians. And if you go, I mean, practiced in other international courts. I remember at the Yugoslav Tribunal, even in very big trials that I was involved in, after the second or third day, there were a handful of people left in the public audience. Every single day, the court is full of Cambodians watching the proceedings. Now, okay, they're bussed in, they're provided free transport, and I think they're provided a small amount of food and something to drink while they're there. But nevertheless, they come and they're interested and they listen. And just to give you some figures, by the end of November of 2012, in Case 2, the ongoing trial, we'd concluded 133 days of trial, and 64,999 people had actually attended the hearings. I mean, that's an awful lot of people if you compare it to the Yugoslav Tribunal. A lot less people attended the hearings there. So I think and 80% of those people were Cambodian nationals. And the real tragedy, actually, is that our current cash crisis will mean that we'll have to discontinue our outreach programs. But that's just to keep the court running. We can't do that anymore. So directly observing the trial process, coupled with the material provided by the ECCC, increases knowledge about the trial process, which is important for establishing confidence in the process itself, and more generally to encourage a perception that a court process is governed by non-arbitrary rules, and it's there for the benefit of Cambodian citizens. So, in other words, actually, by watching the proceedings in our court, actually developing confidence in their own system where there is very little confidence. 57%, actually in a recent survey, 57% of respondents said they felt they knew more about what happened during the Khmer Rouge period after the first trial. But a significant majority of respondents still felt their knowledge of the Khmer Rouge period was poor or very poor. So people say, yes, my knowledge is very poor of the period, but 57% say, well, actually the tribunal has increased my knowledge of that period, which actually indicates that nobody talks about it in society, and it was not part of the educational curriculum. So perhaps, as I say, those results are reflective of the very limited information that was previously available. And we hope that a similar study conducted after the second case will show even more improved figures about this. The trials are very widely publicised. There's a weekly television broadcast. There are also weekly radio programmes. There's regular updates in Khmer language newspapers, NGOs, print, the latest developments. We have a Facebook page and a Twitter account, like everybody else, of course, but nevertheless, we widely publicise the work. Let's now look at victims' participation. For the victims of the Khmer Rouge and their families, this is an opportunity to tell their story and in some cases confront those accused of crimes against them. Through this process, victims take a step towards healing from the horrors of the regime. We provide a unique opportunity for victims and their families to participate in the trial process. Victim participation, and we're going to talk about that after my remarks now, but it's a comparatively novel concept for international or ad hoc criminal tribunals. Even in common law jurisdictions, the role of victims, as you know, is largely to be a prosecution witness. Then, of course, as a victim, the witness can only speak either for the prosecution or the defence. The ECCC, victims of crimes within the jurisdiction of the court, can submit complaints to the co-prosecutors. Victims may also apply to become a civil party, a concept with its origin in the civil law jurisdictions. Both groups participate, so victims and civil parties participate in some way in the proceedings, but the extent of that participation differs. A complainant, a victim who is a complainant, is a person who suffered witness or is aware of any crimes committed under the Khmer Rouge and chooses to submit a complaint to the co-prosecutors. We in turn may use this information to shape our preliminary investigations before the matter is transmitted to an investigating judge for a full investigation. A civil party, on the other hand, is someone who is directly affected by one or more factual investigations under investigation by the court, whereas a complainant's role is limited, a complainant victim's role is limited to bringing the co-prosecutor's attention to the crimes under the regime. Civil parties are fully active participants in every step of the judicial proceedings, and we'll talk about that at 5. So they are a party to the proceedings in the same way that the defence and the prosecution are. For the second case, the case that we're prosecuting now, there were 3,988 applications for civil party status. Overall, it does appear that the participation of victims has been a positive aspect of the court. There are many challenges. We'll talk about that in a moment. In a study of civil party participants from case 1, 10 of 14 civil parties whose family members had perished at S21, which was the principal torture and execution centre of the Khmer Rouge in Phnom Penh, they stated that in confronting Doik, who was the man on trial who'd been the commander of that centre, it represented a pivotal moment in their quest to uncover the truth about the fate of their loved ones. Further, the majority, 17 out of 21 of the civil parties whom we interviewed, characterised their court experience as largely positive, the remaining 4 saying it was a mixed experience. The same study found that overall the civil parties found the trial process to be fair, although they did express dissatisfaction with certain decisions and procedures imposed on their legal counsel. It should be noted that, in fact, there were a number of procedural reforms which we can talk about in a moment after the first trial. So, to emphasise, civil parties have their own counsel before the court. They can give evidence as a witness. They don't necessarily have to give evidence, and often are present in the courtroom. So we have victims literally sitting behind us watching the proceedings go on. They don't stay there for every day. They normally take it in turn. So they're very much part of the proceedings. Let's lastly talk about educational material and how it's affected education. Within secondary educational institutions, we provided an opportunity to learn about Cambodia's past. Many young people are either completely unaware of the Khmer Rouge regime or find it very hard to connect with the experiences of their parents or grandparents. And I genuinely believe, and I've worked with NGOs in this area, that this generation, this younger generation, has had an opportunity to confront the period. For tertiary educational institutions, the historical, legal and political ramifications of the court provide invaluable material for analysis and observation. Tertiary students engage with the court both as visitors and legal interns. In addition, much contemporary Cambodian scholarship is not written from a Cambodian perspective. We're actually providing stimulus for that group of Cambodian scholars to write at these things from a national perspective as opposed to outsiders coming in. We've created a historical record which is distributed to the public, specifically to secondary and tertiary educational institutions. In the original request to the UN, the co-prime ministers then, Prince Ranulrid and Hun Sen, who is still the prime minister, wrote, "We hope that the United Nations and international community can assist the Cambodian people in establishing the truth about this period." Now, in a population-based survey by researchers from the University of California, Berkeley, it was found that 77% of all respondents said they wanted to know more about what had happened during this period of history, while 85% of those who did not live under the regime wanted to learn much more. I think we've made major inroads into that sort of lack of knowledge. And on an individual basis, trials have given victims the opportunity to speak about their experience. For many victims, this was the first time that they'd actually confronted their past or told others about it. In a study of civil party participants in case 1, and this is interesting, one person stated the following: "I kept my whole story a secret. My wife knew I'd been a prisoner, but for 30 years I never specified exactly where I'd been detained and what I'd experienced. The former prisoner's wife would learn the details as she sat with her children watching her husband testify on television during the court proceedings." Let me just conclude. Let me talk very briefly about our engagement with universities and other institutes in the country. Universities and tertiary educational institutions regularly attend the court as part of learning about the trial process in the Khmer Rouge period. A number of Cambodian students, particularly law students, work at the court for a 3 or 6 month period. And this is actually a program that I started at the court in 2010, where the Australian government pays for 6 Cambodian law students to come to the court for periods of between 3 and 6 months. And it's absolutely changed people's lives. We found that all of these law students have subsequently found employment within law firms in Cambodia. Some of them have gone into the domestic legal system. We've had the first female entrant into the Cambodian judiciary, because obviously it's the civil law system, so judges go into the judicial training scheme at a very young age, at a very junior part of their career. They train to be judges. And we've managed to secure, I mean, it'll make you chuckle hearing this at the same time. Normally in Cambodia you have to pay a significant bribe to get a place at the judicial training school, and we've actually had the first female applicant, and it's the first applicant, she happens to be a female, who gained entrance into the judicial training school without actually having to pay this huge bribe. We've just had a Fulbright scholar. So we've had a lot of success stories with the young. I mean, that's where you have to work. I mean, they're the easiest to work with. So that's been a hugely, I call that the jewel in the crown of the Office of Co-Prosecutors. But that has been a really successful part of our capacity building program. So let me just say a few remarks in conclusion. Let me recapitulate what I've said. The ECCC is a court bringing to justice those most responsible for some of the worst crimes since the Second World War. The ECCC is a hybrid tribunal attempting to bring justice with Cambodia as well as for Cambodia. We continue, despite criticism and horrendous funding difficulties, to achieve our aim of prosecuting senior Khmer Rouge leaders with a significant contribution to developing capacity within the Cambodian legal system. As I've said, capacity happens at 3 levels. At an individual level, we're developing skills and knowledge in Cambodian staff members across legal departments. These, we believe, will be transferred to the institutional level. ECCC staff members continue to practice in domestic court systems and can pass on their enhanced abilities to their colleagues within the national system. We also develop the substantive capacity of Cambodian law to be applied in the domestic court system. This enhances institutional capacity because it's applied across the country and at all levels of the Cambodian court structure. Finally, The ECCC is working to develop capacity at a societal level. We generate discussion across a wide variety of legal topics not previously discussed. We are, I believe, assisting in the education of the younger generation about the Khmer Rouge period, and we're stimulating academic scholarship amongst Cambodian lawyers and scholars. In closing, I'd like to convey the following. We are an experimental hybrid court in an emerging democracy, and we faced a lot of challenges over the years, but everybody knew about these challenges when the process was begun, now some years ago. I still believe that as a court, we genuinely foster cooperation between local and international contingents. We're a court that contains many thousands of Cambodians in our operations, and here I include witnesses, members of the public, scholars, and I believe we are slowly but surely transferring international skills and standards to the judicial and legal community in Cambodia, and thus transforming the local system. I truly believe, because of the level of political difficulties in the country in respect of the court, if we had been an international court, I would have been thrown out of the country 2 or 3 years ago. I think the very presence of nationals within the court system has eased the tension in the minds of a fairly autocratic government about the court. So I think that had we not had this structure, for all of its problems, the government would not have had the people in place to reassure them that the process was not completely out of control, that we were not going to be going after senior members of the sitting government. Change, of course, is very hard to implement anywhere, and it was your Robert Kennedy who said, in the context of the human rights situation in South Africa 50 years ago, and remember he was speaking of South Africa in the early 1960s, I mean we need to look at how South Africa is now, he said the world yields painfully to change, specifically in the context of apartheid South Africa at the time. So I believe, even with all the challenges that we have, we're really compelled to struggle and to act and to try and look with some hope to the years and decades ahead for Cambodia, to seek a peaceful and gradual change now, in the present, with the Cambodian people, towards those ideals that we essentially wish for all nations, of a strong and just and decent government. But that, of course, I think is an imperative for all nations, and it's certainly in that entire region, you know, proper rule of law, accountable government, politicians who are willing to go after elections, proper democracy. It's really a work in process in many parts of Southeast Asia. But I still believe it's something worth the effort, and it's certainly still worth being in the arena to be part of this process of change. And I believe certainly that in respect of Cambodia, it's incredibly important what we're doing, even though it flies in the face of many of the naysayers and the critics and the cynics of the court. People who really, you know, they do have a point, but they've got very little to offer in terms of what the alternative solutions are. You know, many of them have told me to pack up and go home. For the moment at least, we've decided as a staff, the international staff, to fight on and finish this job that was started with the Cambodian people 7 years ago. Finally, I wanted to say this to you all. The financial crisis at the court means that the Cambodian staff have not been paid since the end of November of 2012. There are essentially two budgets. There's a domestic budget which pays the Cambodian staff, and there's an international budget that pays the UN staff. The international budget runs out in June, so after that period I may not be paid anymore either. But in terms of the Cambodians, it really is a human crisis as well as an emerging institutional one. Food is not on the family table, school fees cannot be paid because even though the schools are nominally government schools, you have to pay because the teachers are not paid by the government. And the strain is now appearing on many good and decent faces in my office and across the court. Now, the court cannot function with just international staff. There are very good legal reasons for that. In my role, I'm not really supposed to step into the politics of all of this, and I've tried to avoid it over the years in order to sort of preserve my independence. But I think all of the parties who are involved in the negotiations over the funding of the budget, those people that have the solutions in their hands, they really need to address this issue as soon as they can. these people have got to be paid. It's wrong not to do it, and we certainly, in that respect, we don't have a minute or an hour to spare on that issue, because if it doesn't happen soon, the court is going to collapse. Ladies and gentlemen, thank you very much indeed for inviting me. I hope I made some comments that you found useful, and please, if anybody has any questions, I think you were going to moderate the questions.
We'll transition shortly to the discussion on victims' participation, but maybe we could take the next 15 minutes for any questions from the audience.
Thank you so much for sharing with us the various ways that the court has, focused on the capacity building. But as you say, it's capacity building is very important for transitional justice, but it's also very rare that the government would invite international, to the judicial system, because it's a critical part of the sovereign jurisdiction. So I wonder if we will see another case of this kind of hybrid court, and I would like to have your thought about, short of such a hybrid court, what kind of capacity building that the international community can help with this kind of transitional justice?
Well, I think in terms of these very serious crimes, the reality today is that the International Criminal Court is supposed to be the only game in town. That, even for states that didn't sign the Rome Statute, the treaty governing the court, there is provision that the Security Council can still refer. So Syria, for example, with the Security Council vote, could be referred to the ICC. It's politically almost impossible at the moment, but it could happen. So I'm giving you that as a background, because I think the likelihood of this kind of court being established again is quite remote. People have talked about it in respect of Syria, also in respect of Libya, but it hasn't happened yet. If you look, for example, at Libya, where there is a fight on at the moment as to where these individuals who have outstanding arrest warrants against them from the International Criminal Court, Libya wants to try them in Libya itself. And there may be people in the room that know more about this than me, how much governments are assisting the Libyans with their domestic legal system to ensure fair trial rights. For example, in Libya, they have the death penalty, which the International Criminal Court does not have the death penalty. And it's highly likely that if these individuals who've also are subject to arrest warrants of the ICC in The Hague are tried in Libya, they're going to be executed before they ever get to The Hague. I mean, that's the intention of the regime, is to get rid of these people. So I think there are certainly examples of countries around the world where it would be useful to have this kind of model. The only thing is, I think, because of the current financial crisis across the world, the states want it to be done more cheaply. So actually setting up a standalone court somewhere else, again, I think is unlikely. What I have said at conferences is that I believe what you can do is at least sort of implant people that have had this experience, or people from the ad hoc tribunals or the ICC, into the domestic system to at least assist. Now, the problems with that, of course, is that you'd be working in a court which might not actually meet international standards. I mean, and that's been a constant fight even at the ECCC. I mean, we were established with international legal standards within our legal framework. And actually, to date, even the critics have said that we've managed to meet those standards in the first case. But I think that would be much harder if you were working in an exclusively domestic court and you were there as a kind of international assistance person. But I still think there is some kind of prospect that develops from the ECCC that can be used in either domestic courts or other hybrid courts like this one around the world. Although I doubt a hybrid court like this will be set up again for a lengthy period of time. I do think, your comment, where the government has sovereignty over its own judiciary. I mean, in Cambodia, I can tell you that the judges there, I can't really talk in a public forum about some of the examples, but the government has a pretty firm control over the national judiciary in Cambodia, as in many parts of that that part of the world, I mean, the government has control over the judiciary. Now, having said that, there have been some very courageous decisions by the national judiciary within the ECCC. I'll give you one example. Sorry, I know that probably other people could, but let me just give you one example. In the first case, Duik was illegally imprisoned by the government, by the Prime Minister, for a period of nearly 9 years before he was tried. And obviously, we had to give credit for that period of illegal detention in his final sentence because he'd been illegally imprisoned. And in fact, everybody was terrified that the national judges would never agree to this because they'd be going against the government. But they did. They signed off on it. And they actually gave him 9 years deduction for a period of illegal imprisonment that had been imposed by the very government of which they are party members. People couldn't believe it. So it can be done. It's rare, but it happens. Yeah, anyway.
So I have a question with if the court or if it ran out of money in June, what would happen in case 2 when they never?
There is legal provision for this within the agreement, actually. It's Article 46 new. And Article 46 new is the provision in the agreement that envisages the UN withdrawal from the agreement. And in fact, the government, I mean, this is in the press, the government already regards the non-payment of national salaries by the international community as constructive breach of that part of the agreement. So if the nationals don't get paid within the next 3 months, the government is going to ask the UN mission to withdraw and replace all of the international staff with Cambodian staff and finish the case themselves. One of the difficulties of the agreement is that the agreement provided that the royal government of Cambodia would pay national salaries and that the UN would pay the international salaries. But in practice, what's happened is that the international community have covered the national salaries. The salaries of ECCC staff, this does go back to this reverse legacy issue. The salaries of the national staff within the ECCC is probably about 4 or 5 times, actually more than that, actually probably 10 times what they earn in the domestic system. So the government actually doesn't have the resources to pay the national salaries. That's the difficulty. And the international community is now saying, look, you've got to find more money to pay these national salaries. We're not going to pay it all. And the government said, we can't. And you always have. This court's been in existence now for 7 years. You've always paid these salaries. And now suddenly you're saying you're not going to pay them anymore. So I think that's what they'll do. If they don't get paid, they'll pull the plug on the mission. The UN staff will go home. And the Cambodians will finish it themselves very quickly.
This is not directly related to the subject of the talk, but I was wondering if you could tell us something about the political pressures associated with being a prosecutor in a deeply political, I mean, the issues that are being raised are extremely controversial, I'm sure, within Cambodian society. So how do you choose who to prosecute and whom not to prosecute?
Yeah, the jurisdiction, the personal jurisdiction of the court is outlined in the agreement, which essentially says that we are to prosecute senior leaders and those most responsible. And in the recent appeals judgment, the Supreme Court chamber of the court expressed the view that that included senior leaders who were most responsible and also individuals who were not senior leaders but were most responsible. As far as cases 3 and 4 are concerned, the national staff have taken the view that there are 2 other cases other than case 1 and 2, and in the 2 other cases there are 5 individuals. And the national staff have taken the view that these people don't fall within the personal jurisdiction of the court. They do, unfortunately, and in particular after that Supreme Court chamber judgment. So they took the view, they basically said these people were neither senior leaders nor most responsible people. That was the view taken by the national staff, because that was some level of interference coming from outside where they'd been told that that was going to be the position. I took the view, sorry, these people are within the personal jurisdiction of the court. Interestingly, how I dealt with that was I kept out of politics. I never comment on the political situation in the country. In fact, what I normally publicly say is none of my business. You know, I'm not running the country. That's the Prime Minister and the government. What I do say very publicly is, you know, here's the law, here's the book of rules. That's my job. That's what I do. If you don't like, if the politicians don't like the decisions that then change the law. Go to Parliament, get a vote and change the law. That's how I deal with it. I just follow that very strict line, because I think the moment you do get mixed up in politics, you're done, basically.
Do we have time for any more questions, or should we be moving on?
Well, one more question, Kim, yeah.
Can I ask if you have any involvement in the forensic investigation process still at this quite distant stage from the crimes? Is your office involved, as the ICTYOT people so heavily involved in discovering new graves, identifying victims, and do you also, if you do that, do you benefit in any way from the kind of forensic resource bank that's being used in other tribunals, or is your budget limited to the degree to which you can do that?
When we started the process, because of my involvement in the Srebrenica case, I really actually wanted to do that, but the co-investigating judges made the decision that they weren't going to exhume any more graves. So we've never exploited that evidence at all, unfortunately. And that which existed where there had been exhumation, I mean, the human remains were 30 years old. I mean, that bone at that stage, and particularly in that climate where it's so blooming hot, it just degrades, and there's no value. There's limited value. You can actually see, for example, at Chung Ek, which is, you know, the killing fields, you know, most people were killed by, you know, blunt force trauma to the back of the head, because you can see the backs of their heads were smashed in. So, you know, there are limited aspects to it. But no, we never exploited it to the level that the ICTY did, nor, unfortunately, as you say, that would have been something incredibly important for Cambodians, because for them, you know, human remains have a level of significance, you know, even greater than in the sort of Judeo-Christian faith. For them to know where the bones are, to be able to pay respects, it's an incredibly emotional part of their religious faith in that country, and most of them have no clue where their relatives are. I mean, they can go to a stupa with, you know, 20,000 bodies, you know, 20,000 sets of bones, but, you know, who they belong to, no. So, yeah, it's an interesting point. Just to point that Rupert's making is the ICTY not only the ICTY acted as a catalyst for exhumations across the country, but it also was in conjunction with identification of human remains. So many people were able to essentially know that their loved one had perished in a particular place by DNA testing, but we never did it. Yeah, it's a shame. Yeah. Okay, thank you very much indeed.